So
Okay, so you want to proceed today by yourself without a lawyer, right?
not before I let it be known that I still never received my full discovery.
Well, what haven't you received, sir?
I haven't had a chance to go over the videotape because one of the witnesses in the videotape that I know that when I was speaking to him and was saying, letting him know that, look, man, put this stuff back on here because I'm choosing not to buy it here and I'm going someplace else. So it wasn't like I was trying to steal nothing when I told the guy that particularly I wanted to make sure that he's being available to be questioned.
I don't know who he's gonna call. See, this isn't a trial. So this is just your probable cause hearing. So the prosecutor has a very low threshold burden of proof. He doesn't have to put on every witness, he said. He doesn't necessarily have to use the video. He might. And if you say the video means something else, that creates a question of fact that would go to trial for the trier fact to resolve. And of course, you get an opportunity to question about the video in depth at trial.
Also, I'd like to mention the fact that, you know what I'm saying, that it's been a delay because I don't know who these people been coming up here. I've been telling the court that I've been wanting to represent myself.
Well, you've been representing yourself since the last time.
Well, I've done meetings with them at the county jail. They said without the court allowing them to know that I was representing myself, it was certain information I couldn't get. They would not give me.
Here, the defendant begins insisting he never received full discovery and claims the jail withheld legal materials because they weren't informed he was representing himself. The judge pushes back, explaining that Michigan's rules don't require notifying the jail in that manner. The defendant's frustration reveals how people often misunderstand the limits of self-representation. Instead of preparing for the preliminary exam, he's fixated on institutional conspiracies, worsening his own position.
Would not give me. Like the Michigan court rules of evidence. You know what I'm saying? For part of
I've never heard of the court having to tell the jail you're representing yourself. I've never heard of that.
The new technology, they used to have a law library you could go. But now you do everything over the computer.
Okay.
You got to leave a request. In order for them to fulfill your request, they have certain criteria that you got to show ahead of time.
Well, sir, I don't know anything about what the jail's criteria is.
And also, you know, I'd ask, you know, for a standby lawyer.
But they don't do that.
But from my understanding from previous experience, John.
What year was that?
Federal circuit court and from other court.
Federal Circuit Court.
No, I know, and yeah, circuit court. They have done.
This is the state system.
There has been opportunity to have standby lawyer for instances where they could confer certain information that the prosecutor might not want to give to me because he might feel he's better than me or something. Because he feels that my counsel doesn't
Listen, Mr. Dansby. We can't keep.
might allow me to receive.
No, of course you got. That's not true. You have a right to represent yourself and you do have a right to get discovery. But what you can't do is come in here on the day of the hearing claiming that, oh, now you want to stand by counsel. Okay, but I'm telling you.
I'm just saying, well, from my experience, it's always been, standby counsel been set.
I don't know what your experience is. I just know what Michigan and I don't know when you got.
Well, of information.
Okay, sir.
And
The Michigan Indigent Defense Rules, they have a whole new program that's been started
The defendant tries to argue that standby counsel should have been appointed, citing experiences from federal court and outdated procedures. The judge explains, again, that Michigan's newer indigent defense system no longer provides standby counsel unless a full attorney is appointed. This exchange exposes a core problem. The defendant wants the benefits of a lawyer without actually accepting one. As he presses, the judge becomes more exasperated, noting that none of these complaints justify delaying the hearing.
Been started a few years ago. So we used to do standby counsel and anything like that. We used to do that all the time when the court was appointing. Now they have a whole system. They don't pay for that. They say if the defendant wants a lawyer, fine, but there's no quote standby lawyer in their view, so they don't pay for that. I didn't make that rule. The person,
I couldn't verify it if I wanted to without.
Well, the person
without the people in the jail who's running the law library information able to send me the information that I need, because without them having, and for their quote.
Okay, what
unquote-
information
Their
do,
quote unquote.
sir, what information do you think you need just for a preliminary exam?
Your Honor, just,
No, I said for Michigan Defense appointment.
So then, you said it used to get standby counsel.
I said we did before that system was created.
Well, I want all the chance to update on the system, y'all.
Okay, but that has nothing to do with this.
Court rules of evidence.
Your Honor, I'm gonna, just so I can expedite this, and to satisfy the defendant, at the circuit court level, the circuit court has the budget and the ability and the staff to appoint a standby counsel once he gets up there. And once we finish this hearing, he may be up there and he can make that request then, and I'm sure the circuit court will have no problem immediately assigning him an attorney to advise him as he represents himself. As far as the people are concerned, the court has been complied with. He's freely and voluntarily relinquished his right to an attorney. May I call my first
So the
witness?
court, so, yeah, I like to also state that I still haven't received my discovery, and my date was proposed because of some guy who said he was my attorney. I did an extra 30 days, the extra 30 days,
Well, if you keep this up,
that's my attorney.
you
Why
gonna,
wasn't my, why?
you're gonna be here another 30 days. Do you want me to adjourn this case again?
No, I don't want to talk, I'm really actually having dismissed.
No,
For the simple fact that.
we're not doing that.
Or ask for a personal bond, because I didn't have my cases adjourned on other people's. That had nothing.
Sir, you the one that asked for new lawyers or
I
no,
didn't ask for no-
or no lawyer.
ask for any new lawyer because I never accepted the first. I have never signed for an appointment of an attorney from the very beginning, even at.
Okay, sir. Well, we're gonna proceed with your preliminary examination without a lawyer. So you should be happy today that you don't have one. And then when you get to the circuit court, ask them to give you a lawyer. He just said they have a budget for that.
Ask them to give me my discovery.
What discovery don't you have?
See, take-
What tape?
Your Honor, I'm gonna play the tape for him, today anyways. There's no right to it. There's not even a right to discovery before a preliminary exam, technically underneath the court rule. I mean, we deal with this all the time. So this is just an intermediate proceeding. It's not gonna affect anything. As you know, attorneys don't even ask questions a lot of the times during preliminary exams because it creates a question effect.
But they certainly don't call. They might ask questions, but they don't call witnesses.
Not in all situations. With all the preliminary exams, but there's.
Okay. Have a seat, sir, unless you want to stand up for the whole hearing. Call your first witness.
People go to the same Robert Stanley.
Mm.
And Your Honor, I do accept the use of polygons.
Okay, let's see if we can get that working again. Where Jessica is. There she is. Jessica. Now, Mr. Shockley, go ahead and, are you on?
I'm on.
Okay, so I'm gonna go to right laptop. Jessica, can I have the remote? Let's see what we're doing. You tell me if that's wrong. Okay. Input. Okay, this says input 3. It says input 2.
Stand before you sit down, look at Judge Johnson.
See,
Just like wait for
it
it.
comes back to the same thing we got. See that?
What table are you at, Shopkins? Or what table is that? Right table?
I got right. Mm-hmm.
Oh, hey.
See? And it just each one of them comes back to the same screen.
I see, because it's not turning on. Oh, there it is.
Is it on now?
I just saw it.
Okay, let's see now. Hold on. Okay, wait a minute. Now the inputs won't even show up. It's interesting. What did you just do? Now, okay. It's, yeah, MI1. Okay. Still the same. Let's go down to 2.
I see it on two,
You do?
on the camera, on the screen, on my screen. On
Well, something's wrong with the Polycom
the,
because it's not showing the TV.
it's not even turning on.
Yeah, and that was what was happening the other day when I tried that.
I'll have to zoom in.
Can you make a call to get that repaired? Hold on a second. I'm not sure what's going on with that. I didn't know you could see it like that. Cause I was just looking at the screen and I can't see a thing. But you could see it. You said you see it on your Zoom. And it's still on HDMI too? Can you still see it?
No,
Okay, wait a minute. Did you?
I'm still plugged in. I haven't touched it.
I didn't touch anything. Why can't you see it, Jess? That's HDMI too.
Judge, while we figure this out, can I run him to the restroom?
Hmm?
While we figure this out, can I run him to the restroom?
You gotta go now. What am I doing? I don't want him to do it on my floor. We could take a couple seconds break. The defendant needs a restroom. And Mr. Shockley, whenever you're ready.
Yeah, sir, when you are ready, will you please state and spell your name for the record?
Yes, it's Robert Sammons. R would be ERT, last is SAMMONS.
Who is your employer?
Meyer,
What is your job title with Meyer?
Asset Protection Team Lead.
Asset Protection Team Lead?
Yes, sir.
And how long have you been employed in that capacity by Meyer?
Since January of 2025.
Did you receive any specialized training to have that title or that role?
Yes.
And what do you do? What kind of training?
So it's a multitude. So over years, Wicklander, certified, and then different courses in, asset protection and policy related, that kind of stuff.
Are those courses designed to help you detect retail frauds or patterns of retail frauds?
Yes.
When the asset protection witness begins testifying, the courtroom finally shifts from procedural chaos to substantive evidence. The witness confidently identifies the defendant, explains his specialized training, and lays out indicators of retail fraud. His testimony is methodical, professional, and calm, highlighting the contrast between him and the defendant's earlier disorganized arguments. This is where the state establishes a clean, straightforward narrative. Rapid selection of items, suspicious behavior, restroom detour, and exiting without payment.
Were you employed in that capacity on July 26, 2025, around 5:30 p.m.?
Yes, sir. Okay.
And so do you work at a specific Meyer store or multiple stores?
I'm assigned to the one in Southwood.
Is that located at 28800 Telegraph Road,
Yes.
City of Southfield,
Yes.
County of Oakland?
Yes.
On that date, around that time, did you identify a retail theft in progress?
Yes.
And how did you identify that?
In this particular case, it was just, rapid selections of, similar merchandise.
What do you mean rapid selections?
So one of the indicators of theft is, grabbing merchandise without looking at price or without appearing to look at price, size, that kind of thing.
And how did you see this occurring?
On the floor.
Were you physically on the floor or were you watching cameras?
Sorry, I was physically on the floor.
Did you follow this individual,
I did.
as he was selecting items?
Correct.
Do you see that individual you were following presently in the courtroom?
I do.
Will you please point and identify an article of clothing he is wearing?
It's the, over to my left, and he's wearing like a blue, shirt with a white t-shirt.
Your Honor, may the record reflect the proper identification of the defendant?
Yes, so ordered.
Upon following this individual, did at one point he come to the point of sale?
He did.
Was that before, at any point did he try to walk out before coming to those